adding, by the way, to the fun of this case for me, Westlaw was out.
It wasn't working for anybody all day.
Well, it's working now.
Great. Westlaw is a legal
It's a way to research cases.
database.
Oh, Westlaw was down. I have not had access to that, but I've heard other
so
attorneys.
I guess you guys tell me what order you want to.
I feel like we have some. I've got a big list of relatively simple ones.
Okay.
Perhaps I'll just read out on the record. Start the first page or so.
And is this all? Ms. Desai emailed me at 1:42 a list of the list we're going off.
Oh, I guess they're going over evidence.
Defendant's motion and then motion.
Yep. These are the questions that were raised yesterday about potential evidence.
I mean, I guess first of all, make a motion to exclude witnesses.
There's no objection to that motion, and the observation rooms are going to have a sign on the door that says witnesses are excluded.
The state would agree that with the exception, of course, for the victims.
Of course. And I believe that when I was asked, I said, except the victims. So
yeah,
hopefully that'll.
I understand the complaining witnesses do it right to be present.
Okay.
So my motion. I'll say that we've agreed to Megan Stewart. No evidence will be admitted about Megan Stewart receiving threats or filing a lawsuit. We've agreed that nothing related to cyber charges will be admitted. Any events occurring at or around the photograph after Mr. Burton was shot. Any reference to Andrew Johnson's Twitter profile or posts. Any testimony of being done and received Simmons. Officer Brandon Holmes testifying for the fact that he made a parking lot.
Okay.
They're going over a list of evidence that they're not going to use. When they mentioned your name, it was talking about references to you filing your civil suit as well as the interactions from people of the public after.
Well, okay, I guess, let me just try to understand. Why does Mr. Britton knowing Mr. Swinney's name, why is that?
I mean, just to identify him. That's Mr. Schmidt.
So he'll come in. Presumably, Mr. Britton will testify. This is what happened to me on that day. Do you see the person here in the courtroom today who did that to you on that day? He'll say, presumably,
Yes.
it's someone here in this courtroom, and he'll point to that person. the fact that he knows the name of Mr. Swinney, and when he finds out the name, I guess I mean, on the one hand, it seems relatively harmless to me as an effect on listener that someone else said, "Oh, that's Alan Swinney. He shot you in the face." Dude.
Yeah, and
On
they're
the
basically
other
just
hand, I don't
saying that
know
they're
how
not
you
gonna
can-
use
Do we have to
your
ask the question?
filing a lawsuit as evidence against him.
You know, my anticipation is throughout the course of his testimony, he'll say things like, yeah, Alan Swinney shot me, or, you know, just because he knows his name. And so,
The fact that he knows his name seems like that comes in. How he knows his name, maybe. Does his name have to be asked?
and one other big thing is, they've already stated that they're not making a determination.
Sure, I get it. I guess just, I mean, it seems like a de minimis issue to me, one way or the other, frankly.
De minimis being just legal jargon for bare
What
minimum.
harm are you trying to prevent?
We want to make sure based on, I mean, I don't want, I don't want statements to come in that are not admissible.
So, to the extent that Jason Britton might testify, Kodiak is the one who told me Swinney's name, I think that is not hearsay because I think it is offered to show the effect on the listener, not to prove the truth of a matter at issue.
I guess my problem is I don't know who Kodiak is.
Does anyone know besides Mr. Britton know who Kodiak is?
Maybe Mr. Britton does, but I mean, but no, I do not know who Kodiak is. And again, I don't think this is a non-issue.
I mean, here's what I'm gonna say. Don't ask him the question, and who told you his name, right?
This is a lot of what I dealt with on
if
Friday.
in the midst of his testimony, he's like, and I didn't know who shot me, but Kodiak told me it was Swinney. I feel like that's effect on listener and an exception to the
Hearsay rule being
state won't
hearing something from someone
but
else
also-
is normally not admissible in court, but there are exceptions. And it sounds like they're going to say this is one of
Okay.
them. Because it's not so
Witnesses
much what was said, it
describing
was
what
the
is
intent.
happening in a video. Is this all the videos, a particular video?
So it's my experience with, Mr. Vasquez, but it's my experience with this office is they'll play a video, and even though it's plain as day what's going on in the video, we go, okay, can you describe what's happening now? And if we're in a situation where there is somebody, we get in a situation where it's not the witness's perception of what they're seeing in the video that determines what's on the video, it's the jurors. And so putting it, it's like playing a game of telephone. I don't want any sort of comments on the evidence. I want the jury to see the thing. Now, if somebody can say, I'm not trying to be unreasonable here, somebody could say, at a certain point, I was shot by a paintball. Is that where it happened? Yeah. But this whole, okay, what's happening now in the video? What's happening now in the video? What's happening? I'm going to play 10 more seconds and you tell me what just happened. There's too much of a danger of editorialization and skewing the jury's perception of that video.
Are you planning on having people narrate the videos?
No, not to narrate, but I will ask to pause the video and ask questions. We'll be able to see this.
So you're going to ask a witness, so for example, again, if you call, let's just, again, for Mr. Britton, we're picking on him today. If Mr. Britton is asked to watch a video, and I don't even know sitting here today if there is a video of Mr. Britton interacting with Mr. Swinney, but let's assume for the sake of today's discussion there
The
is.
judge has not watched.
So you'll say, is that you, Mr. Britton, on the video?
Yes, it's made positive.
The judge has not watched the video evidence because the IT department has to do
But
extra
you won't
checks on the
say what's
media
happening
before she
here
can
and
access it.
say, we'll watch it. But you could say, do you know where in the city you are in this video? And he could say, we're on 4th Avenue.
Things of that nature, yes, that would be how I would anticipate the context would be. Am I going to ask him, can you tell me, are you walking down the street, or are you yelling at him here? I mean, that stuff's going to play in the game, so I'm not asking him to narrow
Okay, and I'll address the court. It's just there's, for example, one of the videos was shown to a witness at grand jury. That witness was not present when that video was shot, so there's no foundation of knowledge. And foundation that it goes with, is this an inaccurate video, an inaccurate depiction of the video that you watched from that day? I don't want people commenting if they don't have any actual knowledge of the context.
So I think where I feel like we're landing here is if the video involves an actual person who's on the stand at the time, that they may be asked questions to provide context about what was going on and what was in their mind at the time the video is being shot. If the person is, let's say, an officer who was responsible for downloading the video that is now being presented to the jury, and he or she was not present at the time of the incident itself, then we would just be playing the video without commentary?
With one exception.
Okay, what's the one exception?
Not playing the video and asking.
It looks like Mr. Vasquez was the one who handled the grand jury indictment.
I mean, I don't think there's any dispute about the route that was taken. Probably we can object to Mr. Vasquez's.
Okay. Well, I mean, to the extent that Officer Combs can say, I've watched the videos and I agree that this is the route that was taken, I don't see that as problematic for the purposes of explaining to the jury how the map was drawn.
And I don't, in that questioning, intend to play clips or do things like that. I'll ask them, under certain remarks or things of that nature. That's all. I won't play the video itself. I'll just say, I know.
Okay. Next, any testimony indicating a witness believes Alan Swinney or anybody associated with him had an intent to commit violent acts.
Yeah, essentially what, there's, again, statements in discovery saying, well, obviously they were down here to
Oh yeah,
do this.
I forgot you were there.
Anybody that was watching would know that they were down here to do this. That's speculation that is not appropriate for the jury.
Here, what I would respond is saying that the witness's perceptions of what they observe, as long as it's not based on speculation on what they see, if they see someone swinging a flagpole at someone else's head, they could say, yes, where I stood was swinging at his head, and I'm trying to hit his head.
And that's quite different than anybody that saw that would think.
I agree. So I don't know, again, right, like I'm not privy to what you think the witnesses might say here. But I agree with the state that
Welcome to
it
pretrial
is
motions.
observed that an individual committed a violent act that is different than we all knew these guys were coming downtown to cause problems, right? And I'm seeing Mr. Schweitzer nod in agreement that that would not be evidence that the state is intending to elicit. Is that right?
That's correct.
Okay.
And I would like that these rulings and these restrictions be communicated to their witnesses beforehand.
I have no reason to doubt that the state will
memorialized in certain ways that are prohibited, that's going to raise emotions. It's going to create a lot of matters.
I'm sure that Mr. Vasquez and Mr. Schweitzer will tell their witnesses how annoyed I would be if I had to deal with that.
You're either practicing for 20 years or something.
Number 12. Jason Britton's medical records / diagnosis.
You know, I think, again, this is one where it's, I'm not trying to quibble at all. It's just, will Mr. Britton talk about his conditions, his medical needs, and things of that nature? If they're his own personal things. Do I need him to come in and say, he certainly will testify that he works on a doctor, but am I going to say, have him say, I was diagnosed with X? I don't need that. You can just say, he will testify that he has vision. That's his own body condition.
I would agree.
I also would agree. I just want to make sure that it's abundantly clear that I don't hear from Mr. Britton, this is what my doctor told me.
So, I think if he says something like, and the doctor told me to put ice on it and I did, that's probably still fine. If it's, he said I had a subdural hematoma as a result of the MRI that I underwent, I think that probably is verging onto inadmissible hearsay. Probably, unless the state has an argument to the contrary.
Not this time, no.
Okay. We good?
I've taken a note. Thank you.
Like, if he says he told me to take Advil or if he wrote me a prescription, I think that comes in.
I mean, you're into Rule 1002 area as well.
No, I think it's probably effect on listener again. He told me to take Advil and I did.
There's a truth in the doctor believes I have pain, so therefore
I imagine, okay, so Mr. Britton would probably first have to say, I told him that I was in pain and he told me to take Advil. I mean, we're kind of arguing in a vacuum here. I don't know what he's going to say. He's going to say he felt pain, I imagine, and that he has ongoing vision issues.
That's correct.
Okay. Any statement of Alan Swinney saying there's video of X, Y, or Z. I don't know.
So, Mr. Swinney, there's a recorded interview with Detective Jones in this case, what we call witness. And during those interviews, Detective Jones was asking Mr. Swinney about what happened on the 2 days. At certain points, Mr. Swinney says there are videos showing X, Y, or Z. Those statements cannot come in because it leaves the jury wondering. In the event that we haven't been able to find those videos, it leaves the jury wondering, well, why isn't the defendant showing those videos? And it shifts the burden then onto us to have the jury querying why aren't we showing those videos.
Are you planning on introducing those?
I'm not sure because I'm not even sure what statements. It depends on what they written out like, hey, this part is written and says to take a look at it. Or
this-
I can take a look at it. It's not a lot of context here. That's why we remember the statement for information for position.
This is Friday all over again.
Is that referring to Detective Jones? And when you're saying that at some point, was this the exact quote?
I mean, sure, I'll read you the exact one. It's in discovery.
transcript of the interview?
Yes. Alan Swinney was saying, in response to Detective Jones' question that, Alan Swinney is responding to some questions, and he says some people were trying to attack some of the folks in our group, and they got maced as a result of that, and they even say on video that it's on video. They came up and they indiscernible. You can clearly see on video that they really aggressive completely. Right? I mean, if the jury then goes, well, yeah, he just said that in the interview.
So there is you don't have the video.
I haven't been able to find that.
And this is about the 15th?
About the 15th.
15th is like videotape from end to end, side to end.
So, no, there's not. The video that we've received begins at the end of the rally. And Alan is talking to Detective Jones about what is happening during the flag race.
Okay, there's a little more context, that's helpful.
Here's the discovery that they gave to me.
I understand, but they probably gave you a lot of discoveries. So to the extent that we can pinpoint where in the discovery you are trying to have them not have their witnesses testify, that's very helpful.
This represents my frustration on how they get into this.
Well, the boat has sailed, so let's just pinpoint where the discovery is. So are you finding in the transcript, Mr. Vassar, the issue?
I am not, but I will look into the transcript. Is that a defense transcript or is that one from state?
I had this man.
Exactly. So this is the issue, Judge. I don't have that. I have the CD where we provided in discovery, but when counsel tries to reference these things, this is what makes it so difficult. It's like, give us a little hint of like, hey, it's on the CD and it's at this point. And I'd look at that and I'd be prepared for say, but we're not. Because we're playing this game of, he has a transcript, and he wants to come up with some vague thing, and that's the issue we're struggling with.
Okay. So I appreciate that everybody is frustrated about it.
I'm frustrated.
Also, this ship has sailed. So, he is saying, well, I guess let's take a step back. Are you planning on putting Detective Jones on the stand and pushing play on the interview and playing the entire interview Detective Jones did of Mr. Smith?
That's a potential approach the state may take, yes.
Okay. So, I guess there are a couple of ways we can do it. One is that it's played in its entirety.
No, these are pretrial motions. Mr. Swinney is actually going to trial
Have you been able to
tomorrow.
locate these videos that Mr. Swinney was referring to and Detective Jones says no? Mr. Westover seems to not like that approach.
It's suggesting to the jury that the defense claims that it's suggesting to the jury that the defense should be showing certain evidence, and that is never our obligation. It shifts the burden to us.
Okay. So I guess, do you know, I mean, when is the last time you watched this video? Do you know?
It's a CD, it's an audio file.
Okay. Alright.
I don't understand the reference to discovery since that was provided and this is not a hidden thing. So, but do I know exactly from the CD and listen to all of them to pinpoint that certainly? But again, I would step back and say that this isn't a partnership with the state. There's no PA. It's not. There's no creation of. It's just that's it. Why is that? Why is the state shifting burden by playing this is the state?
Well, I mean, I guess, and I'm not saying that I'm persuaded one way or the other, but what I think Mr. Westover is saying is we don't have there's these videos that are referenced by Mr. Swinney. To the extent anyone's tried to find these videos, they are, as of yet, unlocated videos, and God knows if they were located tomorrow, there would be other issues anyway, to the extent that the jury then is like, well, yeah, where are those videos? I guess I can understand that it invites the jury to kind of speculate about these videos that we're never gonna see.
That's the jury instruction that says don't speculate. I mean, there are any number of things that a defendant may say in an interview, and that's where the defense attorney may come in and ask questions to cross-examine, the interviewer. This goes to the weight of the interview. I don't think it is any type of privilege that needs to be set.
But yeah, this trial was originally supposed to start either yesterday or today, and we've
Do you
just
have the
been far enough
timestamp
behind
on
that
I don't. I can. It's early on. It's page 4 of my transcript.
That we're
It's the
not
first one that I,
even ready to start.
See, I'm happy to provide my entire transcript.
that would help.
Okay, read me again. I'm sorry. Read me again exactly what Detective Jones said.
So I have to go back a little bit. Detective Jones question. We're talking about the 15th, and he says, "What day of the week was that?" About 1 in the afternoon downtown, right around 3 in Yamhill. Answer: Yes, sir. Yeah, I'm gonna get rid of all the ums and ahs and just read it through. The flag wave that we did on the 15th. That's correct. Detective Jones. Okay. Answer: we went down to wave flags, and then we got to the Justice Center without incident. There were some people there that were waiting on us whenever we got there. We waved our flags, and it was really shortly after we got there that a few people tried to assault some people in our group. Detective Jones. Mr. Swinney. And they got maced as a result of that, and they even say on that video, that it's on video, that they came up and they, indiscernible, it's clearly seen on video that they were the aggressors.
And we don't think that video is.
I haven't been able to find that.
How difficult is it to edit that out to be able to set it? Yeah, invite the jury to start.
If I have the transcript, then I can do it in fairly reasonable amount of time.
I have an email loaded up. I have notes on the
Okay.
transcript that I brought with me.
Fine. Email Mr. Garcia.
I don't see any other red highlighting in it. I sent them to Mr. Vasquez and Mr. Schweitzer.
All right, next, Mr. Britton's speculation that the flag wavers were downtown to get some kind of media spectacle going.
Similar to my previous one about, anybody that was watching this would speculation.
Mr. Britton going to testify.
I will be
that he
right
thinks
back.
Mr. Swinney and his friends were downtown to get some kind of media spectacle.
I'll talk to him about this and then ask him talk about it.
It's a direct quote from him from Brandon.
state will instruct Mr. Britton not to speculate the reasons for the finding. Mr. Britton testifying that other members of Mr. Swinney's group had concealed weapons.
I will certainly talk to Mr. Britton about only the things that he was able to see on the day.
It's not relevant to any of the charges.
Well, Mr. Britton's personal observations of other people at the protest and what they did or did not have.
I'm back.
Does the state have a relevance theory for that, or are you going to tell him to only talk about what he saw Mr. Swinney have?
It depends on. I believe that the defense is going to be arguing self-defense, and so certainly what the other people have available in Mr. Swinney's group may be relevant to that discussion. Because there's a different analysis of, hey, I'm walking down the street by myself, or am I walking down the street with 10 of my friends and they are armed with swords, batons, and paintball guns. There's a massive difference there in the self-defense analysis.
Person was in any way acting unlawfully. So if there's an effort to explain somebody's behavior because they did something else, then you end up talking out of the thing on the screen. And essentially talking about the lawfulness of
I would say it also goes to these issues of being the first aggressor. I mean, which there's evidence that he brought these people in together. And he's not going to be brought with his umbrella in the church. And the witnesses will testify that they were armed. The video will show they were all armed. And the analysis of is he acting legally is taken from this out of the context of things. If one man walks up to a group of 5 other men and they're all armed, that's relevant into a self-defense analysis. If they all know, like if the 5 men are standing there and they all know, like, I know Mr. Schweitzer's holding a shotgun and this person is holding a baseball bat. It's relevant to that self-defense analysis. And was it reasonable? Was there provocation, initial aggressor, things like that?
So I'm, I guess, stuck on this question of concealed weapons versus.
Yeah, I'll tell him to only talk about what he saw. Like, don't speculate. Did someone have a concealed handgun, or did someone have a knife in their pocket? Like, you didn't see that. That's not an issue. These are very overt things. Like, literally, there's a guy carrying a 5-foot-long sword walking next to Mr. Swinney and a giant shield. These are the things we're talking about.
Right, and they're going to be on video.
Yes.
Yeah, this is a lot of what's been going over on both sides.
The videos I've seen, yeah.
Is
And
they,
so
they want
Mr.
to
Britton
focus
said, like,
only
and I
on
saw the
what
dude with the
happened with the people
long
that
sword,
were
too. You're gonna cross
victims or
Many
alleged
times.
perpetrators.
right?
They want to try to avoid what were the crowds doing.
So, I don't think speculating about concealed weapons is appropriate because I think it's speculation. But what a victim or a state's witness observed that is going to also be on video, etc., I think that's probably All right. Jason Britton testifying as to his opinion that they did not come down for an innocent flag wave.
I certainly won't be asking him for his opinion about the flag.
Okay, then it doesn't sound like you are contesting this information and that you instead agree that that is not true. Jason Britton testifying that to anybody watching, it was pretty clear that Mr. Swinney was there to antagonize.
I think in this area, Your Honor, it's not so much I certainly wouldn't. I can advise him to say. It becomes more a matter of the manner in which he speaks. It's not so much a question. I'm not going to ask him. Well, if anyone was watching this, what would they think? I would ask him. When he's speaking, it's things like, it was clear to me that he was antagonizing. I would certainly talk to him and limit him and say, don't say things like, anybody watching, just talk about what you saw, what your perception was. If his perception was that Mr. Swinney was antagonizing, well, then he should be able to start.
It's just a direct quote from Jason.
So I don't think that Mr. Britton should assume that to anybody watching it was clear Mr. Swinney was there to antagonize, but if Mr. Britton has the opinion based on what he observed, Mr. Britton can testify as his layperson's opinion without that. Jason Britton testifying that Alan Swinney was faking distress as an excuse to give justification to spray a guy in a wheelchair with me.
I believe this is in reference to, there was a moment in the video where there was some discussion about this gentleman in a wheelchair being sprayed with mace. I'll ask him to not talk about faking distress to spray a guy in a wheelchair.
Any testimony that Alan Swinney's paintballs were anything but regular, non-frozen paintballs fired at the regular / factor setting from his paintball gun.
I just think that based on the evidence that they have, there is video of Alan Swinney holding a paintball, shooting a paintball, shooting a paintball gun. There's no, for the ballistics of the things that are coming out, content of the things that are coming out, that rises to the level where Brown and Key scientific opinion, expert opinion.
I think what would happen is Mr. Griffin will talk about that he has been paintballing before, he knows for that, and it's just that's what he has. Does he know that they were frozen? I would say no, and I'll ask him to speculate about it, but he would just testify this is that. There were balls that fired that partner, and so that's why even the Skylar Jorgensen discovery has some of that information. I'm referring to Detective I'm not calling Detective Hoffman. I'm not wanting to seek to listen. I'm still not being shot by a people.
So, I mean, I think if Mr. Britton says he's been paintball shooting before, something about this felt different, but he can't put his finger on it. I mean, you know, that's his layperson's opinion based on his experience as someone who's, you know, shot and been shot by paintballs before. speculating as to what was different about the paintballs, that he thinks maybe they were frozen or thinks maybe the regular / factor setting from the paintball gun was set differently, or that some were harder than others. I don't think that that's probably appropriate because I don't even know how you would know that. But I admit, I'm not an expert.
I've been paintballing once. I know how to explain that.
I don't see, I don't see anything about different paintballs. The only thing I see about paintballs is somebody named Andrew Simmons who was detected Dr. Simmons and his associate Jason Whitman walked on the area of Southwest Park Avenue, Randall Street, on account of protesting and shooting people all affected by Jason Whitman shot.
So the Jurgensen person or whatever his name is on the state's witness list, and he was the one who you said would conceivably have testified about that?
No, he was a co-defendant, not a co-defendant. He was with Mr. Swinney that day, and he was already been prosecuted.
Okay, and you're not introducing his statement?
Nope.
Okay. So it doesn't even sound like that.
I think this.
I mean, the point is there's not anything in discovery other than speculation that Jason's written about there being different types of paintballs.
I'll ask him to avoid discussing this issue further. It's a non-issue, but I'll ask him.
Yeah, and like you said, Megan, in Britain's case, usually when you're paintballing, you have
testifying about
good
the
eye protection.
conclusions his eye doctor made, and as to statements they made to him, I feel like we already kind of discussed that. Yeah?
Yeah, I think we did. I do think we also skipped number 20.
Well, I kind of thought that was, so Jason Britton testifying about how different kind of paintballs break. I feel like that just goes back, I mean, I guess I kind of thought of it as 19 and 20 being sort of the same.
Okay.
I mean, he has experience with paintball.
Not getting hit in the eye. You know when you were hit in the eye once? It was this thing.
Okay. So what does that have to do with how different types of paintballs?
Because he described how it sort of ballooned off of his face and how it would be different for different kinds of paintballs.
Well, I mean, I'll say this. Someone who has been paintballing and has experienced it and been involved, sometimes paintballs break and sometimes they don't. It doesn't mean that they're not a paintball, just because sometimes they hit you and it's a different sensation because it doesn't actually break. That's what he's referring to, I believe. And so if he's able to testify and say, that's my experience is that sometimes they don't break and it hurts. I don't see the harm in that, really. It's his experience, his perception.
I mean, I think as long as he doesn't say, like, therefore, I have assumed it was frozen and or some sort of altered special paintball.
There's two different kinds of paintball. Paintball with paint in it, and then there's another kind of paintball called a rubber reball. One of them is rubber reball because it's reusable.
Okay.
Jason Britton testified at a grand jury that rubber reballs cause more damage. They're designed for a different type. He's not quite right, but he talks about these different kinds of things. I don't want him to say. I don't think he can say that it was a rubber reball.
I'll ask him what he's basing his knowledge upon. When I discussed it with that out of court, if it's purely just speculating there's a reball, then I'll tell him this explains it was shot by a paintball. If it is not right, don't speculate.
Yeah. A lot of this could just be sorted out if the two of them would talk.
And I, to the extent that Mr. Britton is willing to talk to Mr. Westover ahead of time and explain what he intends to say, that may make things go more quickly. Okay. So 21, we're fine. 22, we're in agreement. 22, Brittany, Carol, or anybody testifying about people having screws coming out of their shields.
Oh, I remember hearing that rumor.
It's the same thing. I mean, she's
Basically making spiked shields.
people that are in the crowd that are associated with Alan Swinney, but it has nothing to do with Alan Swinney's conduct. Alan Swinney does not have a shield on his screen.
Are there videos of people's shields with this?
There are, and there's a video of Mr. Allen Sweet standing basically over the top using the shields as a barrier so that he's able to shoot other people. There's that.
So, and Brittany Carroll is a witness that was on the scene at the time. Okay. And her perception is that the shield had to be.
Yes.
Is seen holding one of those.
No, not holding it. He's standing behind a line of people.
Okay.
Have them.
I think that is relevant evidence. I think that Brittany Carroll. Brittany Carroll or anybody testifying about Alan Swinney posting quote hate speech on social media.
Not, yeah, I think we said that we're not going to do. We really not going to send them directly.
Not bring in on direct exam. And last, Megan Stewart testifying that paintball may have been.
We will not be bringing in that testimony on direct.
All right. Okay. Is the next thing we need to take up the self-defense issue?
The state's motion?
Yeah.
State would like to.
Is that the state's motion in limine to exclude unrelated other acts evidence?
Yeah. And it relies on spring. What is, I guess, and so, I mean, I think what I need to understand probably a little bit is, let me take a step back. In order to evaluate my legal position on this, I have to understand both the subjective belief of Mr. Swinney as well as whether or not that was a reasonable belief and whether or not some of the stuff comes in. Do we agree that that is the state of the law? And so, understanding that things may or may not change as the trial goes on, how would
My memory's a little more
evidence
faulty.
of an incident from another protest be coming in?
So, a couple of things. We're talking about August 15th.
Okay.
There's a man named Andrew Duncan who's present on one of the videos.
Okay.
He is walking close to with Mr. Swinney during this. On his chest, there's tape, white tape, and on the tape is written, "Do not stab." Earlier on a video, there is a back and forth between the folks that are following Mr. Swinney's group, as well as and talking about, you guys do violent things, you guys do violent things, that sort of thing. And one person turns around and says to one of the pursuers, they're talking about Andrew Duncan, saying he got stabbed a few weeks ago. I think that there is an inference that can be drawn that Alan is going to be close proximity with Andrew Duncan for that thing on his chest saying, "Do not stab." It is an inference that Alan is going to know about. It may go to wait, but if I see somebody, if I see somebody with a colleague of mine with a sign on their chest that says "Do not stab," I'm saying, "What's that all about?"
Uh-huh.
And they would tell me who that was. So I think that would also be if we're talking about the reasonableness.
It's crazy how much stuff feels like it's common sense, but because it's legal stuff, they have to be very careful.
I think it. Here's the thing I'm stuck on right now. I don't know. The evidence is not before this court right now. The timing of Mr. Swinney potentially talking, if he did talk to Mr. Duncombe, I don't know. I don't know if he talked to him. I don't know when he
Yeah,
talked
we
to him.
don't know who the defense's
the fact that
witnesses
in the
are at
middle
all.
of all
They're
of
under a
this,
court order.
There is some colloquy that is
And I
heard on a
suspect
video
Duncombe, from what I'm hearing,
that
would be
Mr.
one of the
Swinney is a
witnesses
part
they're more
of in the
likely to
midst
try
of
to get.
I'm assuming, though I haven't seen it, chaotic scene. I don't. That information, I don't believe, is sufficient to say that it comes in as part of what has formed Mr. Swinney's subjective belief that he needs to defend himself or others. What am I missing?
We're talking about.
Yes, I have a
foundation
big water
issues.
dispenser
I think
right
that
next
if
to my desk.
Mr. Swinney were to take the stand in this case, and if he were to testify, Andrew Duncan told me that he got stabbed by Antifa 2 weeks before at one of these events, then that would adequately lay the foundation of his knowledge as it relates to his self-defense claim. I don't know if Alan's going to testify or not, but I think we would get there. But I think we're talking right now about foundational issues. The state's seeking to exclude entirely, even if a proper foundation is laid, by saying that it's not that knowledge is not relevant, and Strickland is very easily distinguishable.
I actually agree. I think Strickland is distinguishable. So, I mean, I guess I'll say this. If Mr. Swinney takes the stand and he testifies that he knew, I think that does come in. Why am I wrong?
So, Judge, there's a number of problems with the defense theory of why this is. There's also problems with the foundation that they've described, but we don't need to get into that, because even if they can lay the foundation, the problems are that, and this goes back to the discussion we were having earlier about Mr. Swinney's parlor posts, and what was at that point the defense argument that what that would be to affect, what the purpose of putting forward this, my buddy got stabbed on a date prior, would be to, so the jury can infer, therefore, Antifa is violent generally, that this group, because they are leftists, are therefore also violent, and because the victims in this case were part of that leftist rally, they must also be violent. That's part of the problem that, again, this was being argued essentially on the flip side by the defense. That's a problem.
And they lost a lot of that.
Well, again, the direct reference that has to be drawn is that it's because there were violent people at a different but similar rally before, this one must also be. It would be different if, it would be admittedly different if Mr. Duncombe, or testifying about hearsay about Mr. Duncombe's incident, said that guy in the crowd standing next to Jason Britton is the guy that stabbed Andrew. That would be potentially in that world of evidence that would be relevant to Mr. Swinney's state of mind, why he would be concerned and would need to defend himself.
I feel that is all fertile ground for cross-examination of Mr. Swinney.
But that would be true of the evidence in Strickland, excuse me. That would be true in Strickland too. The state could have cross-examined the defendant on that point as well.
Okay, well Strickland, let's be clear. Yes. What Judge Ryan, ruled in Strickland was that Mr. Strickland pulling a gun at a protest, ostensibly in self-defense, that
my understanding is Strickland is a case that happened right in this same area geographically at the Justice Center.
When I was at a restaurant taping some dude, he got mad at me and beat me up or broke my arm or whatever. That's a very different, for two reasons. It was a year ago. It was one person. It was at a restaurant. Here, I actually think if it was, and 2 weeks earlier at the protest involving similar characters of people, I got my arm broken with my camera, and that's why I brought my gun the second time. I don't know that I think Judge Ryan would have excluded that.
But I think that's a difference without a distinction. Just because that was part of Judge Ryan's analysis doesn't mean that if those factors aren't present, that changes the analysis here. There still are significant differences in this circumstance involving. Those distinctions, again, require the differences highlight why it does not advance an argument that Mr. Swinney's, if he did in fact perceive a threat, was reasonable. That's part of the court's analysis. The defense does not get to bring in every single thing that made him perceive a threat. It has to be reasonable. That's, I think, the heart of Strickland, is the defendant does not get to bring in every prior incident or every fact that caused him to perceive a threat. It has to be related to why a threat was reasonable.
And I just don't think that's what Strickland says. I think that in certain, what we're talking really is relevance. And what Strickland has is based upon the facts that we're talking about, as Your Honor identified, a year ago, a completely different group of people in a completely different situation. The ruling essentially there said that just doesn't get over 401. It's not logically relevant. And Strickland has language that seems to look bad, but you actually read the case for what it says, and it talks about exactly what you're saying. It distinguishes it. So this was not a case that, it was similar parties or along those lines. And I guess the last thing I'll say about that is, I don't understand how the state's been moving to introduce all of these other statements of Mr. Swinney for the purpose of rebutting self-defense, and now they're saying that it's a two-faced argument.
The biggest issue here is that the defense argument and their theory of relevance is true. And that opens the door to every piece of news or rumors that Mr. Swinney might have heard. Hey, people have guns at these rallies. People are going to, hurt us at this rally. It would open the door so widely. And again, when we're looking at a self-defense argument, we have to be specific about threats and then about the evidence towards those threats. In order for the defendant to prevail on the self-defense, he has to make the argument that the threats of the people, his actions are necessary because of threats relating to the people that he harmed. And so saying that a guy got stabbed 2 weeks earlier, who by all accounts was not at this event, and was not present near or anywhere in the vicinity of Mr. Britton, it's so far afield from the circumstances of this case that it requires, essentially it's going to just be asking the jury to say, hey, there were violent people at a previous protest, which means there were probably violent people at this protest, which is absolutely propensity evidence about a whole class of people that attend protests. And it would ask the jury to then use that propensity evidence, again, to apply that to the whole group of people that showed up on these particular days, and that somehow that makes it reasonable for Mr. Swinney to start attacking random people.
I think that goes to the weight of the evidence, not the admissibility of the evidence. I will say, I think the only way that it comes in is if Mr. Swinney himself testifies to his personal knowledge of it. And so, to the extent that there is reference made and Mr. Swinney decides ultimately not to take the stand, there's going to be some real limiting instructions given to the jury about how they have to disregard everything that they've heard. I don't disagree entirely with the state about the problems with the evidence, but I feel like it's subject to the cross-examination of Mr. Swinney, and it's going to be subject to probably a limiting instruction.
Yeah.
And so
there's just too much we don't know.
And I also don't agree with the state that it opens the door to everything else. I think it opens the door if he testifies he has personal knowledge that Mr. Duncombe had been stabbed 2 weeks earlier and that had him more on edge, I think we have to allow him to pursue self-defense.
I have
Whether
to
or
say,
not the jury
from
ultimately
what
finds
I've
that to
seen
be objectively
in this
reasonable,
case
I
so
think
far,
it's
it feels
an
like the
open
defense is
question.
just
And
going to
furthermore,
have to
I would say, depending on how
try
the
to
testimony
weaken
comes out,
the
this
ability for
probably
the
would
state to
open
make
the
an
door to some of those
argument,
other parlor posts on cross-examination. So I'm just saying, I don't know
as
that for
well
sure because I don't know
as
exactly how it's
just
all going to
throwing
come out.
everything
But
else at
I'm
the
just,
wall and see what
you know,
sticks.
I'm not going to. I don't want there to be a lot of, you know, sad faces if I start letting additional parlor posts in once the door gets opened. I don't know what's going to happen. But.
Oh. Oh. I think she's one of the defense. Yeah. He probably doesn't want to take that chance now
Not really
because
getting it.
Yes, you are, but go ahead.
it's
No, truthfully,
pulling
Okay.
together
the second piece of
extra
the
parlor
motion
posts
was
is not going
only
to
Mr. Duncombe,
help his
but
defense.
but evidence of separate acts by essentially random members of the large group or groups that assembled on the 22nd of the 15th. I think we have a little more sense of what the defense intends to introduce with that. We have the 5 videos that it announced that are likely exhibits or potential exhibits. In those, there are at least a couple videos that show. It's a little bit difficult to tell exactly what's happening, but at least a couple of incidents where they're showing people on the groups opposed to Mr. Swinney's group, with there's some kind of bag of, I'm not sure what, but they're kind of hiding it, and then there's an interaction with the person who's taking the video. This happens well away from where Mr. Swinney was during the event. It happens essentially again on the side opposing Mr. Swinney's group. The camera angle makes it clear that he's not with the cameraman to see what's happening. And similarly, there's another video that
would
shows
question
a
admissibility.
guy, again, not clear who he's affiliated with, but appears to be opposing Mr. Swinney's group, holding a knife for approximately 20 seconds. So, again, having a interaction
Okay,
with other
just
people
keep
Mr.
in
Swinney's
mind
group. And
they
in
may
that
not
video
be able to
particular,
use it.
About 50 seconds later, that clearly that Mr. Swinney was some distance away in an entirely different part of the, that strip of in front of the justice. So, again, with evidence like that the defense might intend to introduce for the purpose of advancing the self-defense argument. As the court noted with the Duncan issue, if Mr. Swinney's not there, doesn't see that, doesn't perceive those things, those potential threats, it's not relevant to their self-defense argument or the case more broadly, and it would be prejudicial under a 403 analysis, because again, it invites the jury to say, oh, that entire group, whether Mr. Swinney was aware of it or not, is violent, and therefore had it coming, or something to that.
Okay. Do you disagree with that?
Yes.
Okay, why?
I mean, Alan's account to the detective is describing all of these things happening, particularly on the 23rd. People were throwing things, people on the other side were engaging in acts of violence, not just him, but to members of his group. And to the extent, what those videos show is the scene. It shows the scene that there are rocks being thrown by the other side and people forming aggressive, I don't know, phalanx-style shield walls against the people that...
Wait, shield wall is the normal term for it.
It provides context for the scene, which there's going to be not just the defense itself, but there's defense of others as well, and it goes to the reasonableness of belief that provides corroborating information that these are the types of things that we see.
Okay, here's where I'm landing on this, and then it's your turn.
It is.
What Mr. Swinney
Oh,
learned
4:30.
after the fact
Mr. Swinney has
by
to
watching
leave,
videos is
or
not
else he
relevant to his
risks having to get
objective
held
purpose of
at
reasonableness. So to the
Justice Center
extent
for a
that
few
things are
hours.
occurring outside of his presence, even if they are on video, those are not relevant. So at least the two examples that the state gave, I agree, would not come in. If Mr. Swinney testifies that he had a rock thrown at him by someone in the crowd, then Mr. Swinney can testify to that. But he can't say, and then I saw a video from earlier, or my buddies told me that there were rocks being thrown at them down the street from where I was. That's not relevant.
Under at all, a depiction of a violent scene that Mr. Swinney is very clearly at, and there's no
Oh, he
specific
does not want to lose
during
this
the
one.
course of these, the fact that he didn't see this specific rock that was being thrown doesn't provide corroboration of his account that there's a violent mob attacking him. And
They're
so-
not attacking him. They're attacking other people.
And he is, the defense of others is
But he doesn't get to say, I was defending every single person within a 2-block radius. Defense of others is the people that are right there with him that he thinks he needs to defend. Not that he's some sort of super soldier who's gonna fly with his, body armor.
It's
down
like
the
I
street.
said before.
really,
She's got a really good personality,
perhaps you're
and she seems very tough and fair, and
I mean,
I like this judge.
it's absolutely relevant. If anything, what we're talking about is him asking that he's talking about other acts evidence, and there's very clearly an other acts evidence exception that allows information to come in, providing context and necessary background information. So to the extent that we can corroborate that this is a chaotic situation where items are being thrown into the crowd that Alan Swinney is in, and essentially the circumstances of what happened there was a Back the Blue rally that was in front of the Justice Center. A Antifa group started showing up on the other side, and things started to be thrown. It will then be shown that Alan Swinney and the people that he was with stood in between the folks who were waving the flags and the folks that were throwing urine, frozen water bottles, chunks of concrete, golf balls.
I think she's my favorite judge I've
shooting
dealt with
projectiles
yet.
And it absolutely is defense of others if you get in between a group that is seeking to do damage to the people behind you.
What I heard the characterization of the evidence is that Mr. Swinney was not within the area to perceive the particular evidence that the state characterized. That there's a knife and Mr. Swinney is not there. That there's people looking in a bag and Mr. Swinney is not there. If Mr. Swinney was not present to perceive the threat, then he can't have that evidence.
Exactly, Meg.
It's the same thing
And then
as saying,
if it wasn't you, he would
it's
have ended
not
up
fair
hitting
to
someone
Mr.
else.
Swinney That Jason Britton says
It's still an assault. Being a bad shot doesn't. Oh God, no! I've seen
those are on video.
some of the stuff
The
he
shields are on
says.
video, and Mr. Swinney is within the proximity of them. That's what about this.
There's no evidence that on the video that Alan Swinney actually was the shield. We want the information from these incidents to come in. We don't want the state to whitewash the violence that was occurring down there against the group that Alan Swinney was a part of.
Are any of the videos of the actual people getting? I mean, that's all coming in, right?
Well, the state's theory of the unlawful use of the weapon is he's committing the crime the entire time he's down there, and they won't name an individual person. So yes.
Well, the difference is this: the state's going to present videos, and they're videos that either Mr. Swinney's in, or where the witness or the victim's in. That's the difference. We're not presenting, because it takes a place for home watch, right? And we're talking about Mr. Swinney's action. So if he's down on one side of the block, and then on the other side of the block, there's a guy standing with a knife. Why does that come into his subjective and what he...
It doesn't.
That's the issue. That's what the state's put through.
It doesn't. If Mr. Swinney testifies that he saw a knife, that's coming in. And if the video corroborates it, that can come in. But if Mr. Swinney didn't see a knife from what I am hearing is hundreds of feet away in a crowded, chaotic scene, I don't think that's
I think you're gonna have to watch that.
okay. I'll see you guys at 8:30 tomorrow morning, and you can watch the videos. I'll try and get Swift to reflect 8:30 for Mr.
The Swiss is one of the jail systems.
So I received the disc from his counsel today with the videos. I put them on my computer so I can be able to grab them. The disc problem with the court's computers is an issue.
Probably the same disk problem that Mr. King experienced when he did with his idea.
I think we can email something.
Do you object to him emailing me the videos so I can watch them tonight? All right, if you can figure out a way, even up to and including, like if you can put them in a Dropbox that I can download on my personal home computer, then I won't be in violation of the judicial department rules.
Do you have them in a different?
They are on the record.
I don't even know that we have anything that places
Or that advanced.
And Your Honor, before we go off the record, I wanted to make it abundantly clear that I'm particularly concerned about this. I understand the gave that sense of absolutely experienced and instructed in physical on and what's in and what's not absolutely allowed by Your Honor. But Mr. Britton's testimony both on the video and then on the jury and police officer, I would like to put the state on notice that we will be asking for a mistrial if any of that comes in. And asking him the question is not asking him the question is very different from the witness being told that if they decide to just not follow the question and just go ahead and go off script, that we will be asking.
And this is the issue I have, is this kind of gotcha game. I will talk to the witness. I will explain to him that these are the areas we discuss in court, and this is what you're not going to say. He's an animated character. He is. I'm not going to direct him or ask him questions for what the court's rules were, but this is this, you know.
I understand. Make it clear to him that he would be risking the entire case if he says it, and if he does it anyway, we'll figure out how to do it.
Thank you.
See you all tomorrow at 8:30 a.m.
Mainly because the case law on the mistrial is terrible, and the whole idea of limiting instruction after we
No disc drive, man.
Do you have a preference?
Nathan, you have a Dropbox?
Okay.
So just email me once you figure it out.
Yeah, so that's where we're at now. Oh, they kicked the chat. Okay, so yeah, we're done with court for today. It sounds like the motions that we just heard, they're going to revisit early tomorrow at 8:30 with the jury showing up at 9 and probably being ready to start the opening arguments by about 9:30. I will set my alarm to get up earlier tomorrow to be ready for 8:30. I don't know if they're going to stream it to make it available or if they're going to wait until the jury comes in. So yeah, we'll keep an eye out. Whatever platform you're watching on, just go ahead and subscribe so you can get notifications when we go live. I'll also have updates that go out on Twitter. Links to all that stuff should be down in the video description. And yeah, we're going to call it a night. See y'all in the morning.